In news that we are breaking to you on Monday, the Delhi High Court raised several questions on the recent amendment made in the Posco Act. The High Court in its observation said that seeing the recent cases of rise in child rapes, quick amendments have been brought in by the centre. But has there been any research done before that? The court also observed that the law has been made strict, but nothing much seems to have been done for the victims. Meenakshi Banja on the phone line with us. Meenakshi, you had raised this issue earlier, whether the centre was in a haste to be seen as doing something, which is why this amendment to POCSO was brought in. The Delhi High Court, I believe, has made some strong observations. Can you take us through them, please?
Well, Afrida, at the outset, it is very pertinent to, one, highlight for our viewers that these are all in the nature of oral observations. Yes, indeed. The High Court has been concerned, and in pursuance of that, like you rightly referred to, it made some observations pertaining to the recent amendments in the POCSO Act. Primarily, the thought behind the observations of the High Court was it wanted to understand from the central government if these amendments were perhaps quick fix measures or if some research or study has indeed gone into it. And secondly, it wanted to understand from the central government if indeed there were some provisions or benefits in these amendments for the victims as well. Because remember, the amendments so far talk about how there are going to be harsh measures for child rape accused and also extension of sentences for those convicted. But really, we have not seen any feature come out in favor of the victims. So that was one overriding concern of the High Court. And also the High Court was observing if much is being done or the area of sensitization of minor offenders is being looked into by the central government.
Right. So these are observations at this stage. Will it have any sort of legal binding? The amendments have already been cleared from what we understand. And this, of course, amounts to death penalty for child rapists. Already we have questions now arising that, why has this distinction been made for rapists of children as opposed to those of adults?
Whether this will really have any far-reaching import, one cannot prejudge. Perhaps it may not, because it is very well within the central government's might to bring about an ordinance, promulgate an ordinance, and if it is also within the executive rule-making powers of any government that has the numbers in the lower house of parliament to see an ordinance through. So it may not have any far-reaching import or an impact insofar as the reality on ground is concerned, but nonetheless, these are concerns that are being expressed by the High Court, and therefore perhaps it deserves some merit and consideration that the High Court wants to understand if really more is being done insofar as alleviation of hurt for victims is concerned. And why child rape, Afrida? Because the central government on many occasions in the past has expressed its growing concern with mounting a spike in cases of child rape across the country. While rape in itself is a grievous, dastardly act, child rape is doubly so, Afrida.
Yes,
and therefore we have seen earlier instances of Madhya Pradesh, even Haryana government expressed a concern about it, and the central government really moving in the backdrop of the Kathua incidents and bringing in these provisions to perhaps make it more of a deterrent so that there can be a curb on these growing instances.
Right. Thanks, Meenakshi, for joining us with the latest information on this big story.